The judge signed the order right there in the courtroom. No delays, no continuances, just a pen hitting paper and a chapter of this mother's life permanently closing. Her ex never showed up. Not once. Not for the hearing where he had every chance to fight for his child. Not for the status conference. Not even when the judge gave him an extra month out of sheer legal courtesy. And now, a man who walked away from his daughter is about to lose her on paper too, forever. But here's where it gets complicated. There's a 63-day appeal window. And the question hanging over this family right now is one that thousands of parents in similar situations face every single year. Can someone who couldn't be bothered to show up to a single court hearing actually undo all of this? That's exactly what we're going to break down today. Terminating someone's parental rights is one of the most serious and irreversible legal actions a court can take. We're not talking about modifying a custody arrangement or adjusting a visitation schedule. We're talking about completely and permanently severing the legal relationship between a parent and a child. Once it's done, that parent has no rights to custody, no rights to visitation, no legal obligation to pay child support going forward, and critically, no inheritance rights. The child is in the eyes of the law no longer theirs. This is why courts don't do it lightly. Even in cases of clear abandonment, even when a parent has been completely absent, the legal system builds in protections, procedures, and multiple opportunities for the parent in question to respond. The story we're looking at today is a perfect example of just how patient the court was and how thoroughly the absent parent's own inaction sealed his fate. Let's go back to the beginning. A mother in Michigan found herself in a position that many single parents know all too well. She had moved on with her life. She was remarried, her husband was ready and willing to adopt her daughter, and the biological father, her ex, had essentially disappeared from the picture. In Michigan, when a step-parent wants to adopt a child, the biological parent's rights typically need to be either voluntarily relinquished or involuntarily terminated by the court. There's no workaround. The law requires it. So this family did everything right. They filed the necessary legal paperwork to begin the involuntary termination process. They showed up, they were prepared, and then they waited to see if the ex would do the same. The first hearing arrived, and to his credit, if you can call it that, he showed up for this one. But rather than engaging with the substance of the case, he requested more time to find an attorney. Now, this is a completely legitimate request. Courts take due process seriously, and the right to legal representation matters even in civil proceedings like this. The judge, doing exactly what judges are supposed to do, granted him an additional month. Not only that, but the judge scheduled a follow-up status conference, an in-person check-in where the ex would need to demonstrate that he had, at minimum, made contact with attorneys. Not hired one, not filed anything, just shown that he was making a genuine effort. That's a remarkably low bar. Contact an attorney. That's it. The status conference date arrived, and the ex didn't show. There was no attorney, there was no communication, there was nothing. The judge, now having clear evidence that the additional time granted was not being used productively, scheduled the official termination hearing for approximately 3 weeks later. 3 weeks. One more chance. The termination hearing came, and once again, the ex was nowhere to be found. The mother took the stand and testified. She laid out the facts of the case, the history of the father's absence, and the life she and her husband had built for their daughter. The judge listened, considered the evidence, and ruled in the family's favor. The parental rights were terminated, and in an almost cinematic moment of finality, the judge signed the order while they were all still sitting in the courtroom. Now let's talk about that 63-day appeal period, because this is where understandable anxiety can creep in for a family in this situation. 63 days feels like a long time to be in limbo when you've just watched a judge grant something you've been working toward for months. The question this mother asked is one that deserves a real, honest answer. How likely is a successful appeal from someone who didn't bother to show up? The short answer is not very likely at all. But let's unpack why. In Michigan, as in most states, an appeal of a termination of parental rights order is not simply a do-over. You can't appeal just because you're unhappy with the outcome. To succeed on appeal, the appealing party generally needs to demonstrate that the trial court made a legal error, that the judge applied the wrong legal standard, that evidence was improperly admitted or excluded, that the parents' due process rights were violated, or that the decision wasn't supported by sufficient evidence. Here's the problem for this particular ex. The court gave him every opportunity. He was notified. He showed up to the first hearing. He was granted extra time. A special status conference was scheduled just for him. He was told explicitly what he needed to do, and he did none of it. Courts are not sympathetic to appeals from parties who were given due process and simply chose not to participate. There's also a concept called a default in civil proceedings. When a party fails to appear after proper notice, courts can and do proceed without them. The record in this case would clearly reflect that notice was given, extensions were granted, and the absent party still failed to engage. That's not a foundation for a winning appeal. That's a record that essentially tells the appeals court this person had every chance and took none of them. Additionally, consider the practical reality. Filing an appeal requires resources, time, money, and usually an attorney. This is a man who apparently couldn't manage to contact a single lawyer during the extra month the judge gave him for exactly that purpose. The likelihood that he suddenly marshals the legal resources and motivation to file a proper, substantive appeal within 63 days is based on the established pattern quite low. And there's one more piece of this story worth noting, because it matters both legally and emotionally. 7 months before this termination hearing, the same judge, in a separate proceeding, had already legally changed the daughter's last name to match her mother's and stepfather's. The ex didn't show up for that hearing either. This isn't a pattern of one missed court date. This is a consistent, documented pattern of disengagement from this child's life and from any legal proceedings related to her. That pattern matters. It tells the court a story that no amount of last-minute appealing can easily undo. So what can you take away from all of this, especially if you're watching because you're in a similar situation or thinking about pursuing something like this? First, documentation and consistency matter enormously in family court. Courts watch patterns of behavior over time. If a parent is consistently absent, not just from the child's life, but from the legal process itself, that creates a record that is very difficult to argue against. Every missed hearing, every unreturned notice, every skipped status conference becomes part of an official record that supports your case. Second, the process exists for a reason, and following it protects you. This family didn't cut corners. They filed properly, they showed up, they testified, they let the court do its job. That procedural integrity is exactly what makes the outcome durable and why an appeal is unlikely to succeed. If you're pursuing termination of parental rights for a step-parent adoption or any other reason, work with a family law attorney in your state and follow every step of the process carefully. Third, understand the difference between an appeal period and actual danger. A 63-day window for appeal is not 63 days of uncertainty about whether your family is intact. The order is signed. It is in effect. The appeal period is simply the time frame during which a challenge can be filed. Given the circumstances here, the realistic probability of a successful challenge is extremely low. That doesn't mean you stop paying attention, but it does mean this family can breathe. And fourth, if you are the parent facing a termination hearing, please understand that ignoring it does not make it go away. In fact, as this case shows so clearly, ignoring every stage of the process is precisely what leads to losing your rights entirely. If you receive notice of any family court proceeding involving your child, take it seriously. Show up, get legal help. Even if you ultimately lose, participating in the process protects your rights in ways that absence simply cannot. The daughter in this story is growing up in a home where she is loved, wanted, and legally protected. Her name reflects her family. Her stepfather is in the process of making their relationship official in the eyes of the law. And the person who walked away, through court date after court date, hearing after hearing, has now been formally and legally recognized as having done exactly that. The system, imperfect as it often is, worked the way it was supposed to here. It gave every party a fair shot, and the outcome reflected the choices that were made. If this kind of situation has touched your life, whether you're navigating a step-parent adoption, facing a termination proceeding, or trying to understand your rights or the rights of someone in your family, you don't have to figure it out alone. Drop your questions in the comments below. We read everything, and your question might become the topic of a future video. If you found this breakdown helpful, please subscribe. We cover real legal situations in plain language because understanding the law shouldn't require a law degree. See you in the next one.